Well, hello, ladies and gentlemen. I'm Philip Harris. I'm a partner in Wright Hassall's construction department, and this is the fourth in our series of Law Bites takeaways, which replaces, in the COVID period, our Friday lunchtime sessions, which we normally give. And our topic for today is aspects of design. So I'm just going to lead you gently through some features of design and design law in construction. So the first thing is to compare contractors' liabilities and responsibilities with the professionals' liabilities and responsibilities. And generally, the professional comes out better than the contractor. So as regards professionals, going back to 1838 and the case of Lamphia and Phippos, the court said every person who enters into a learned profession undertakes to bring to the exercise of it a reasonable degree of skill and care. So there we are, it's reasonable skill and care. The duty of the professional designer is limited to exercising reasonable skill and care, and he's judged against his peers. So brain surgeons are judged against brain surgeons, general practitioners are judged against general practitioners, and they're judged by people exercising the same art or skill in the same way. And as I say, the standard is simply reasonable. So they're not promising in relation to their design that it will achieve fitness for purpose. Contractors, on the other hand, and just take this broadly, usually will have to exercise both reasonable skill and care in their design and meet a fitness for purpose obligation in relation to the products they supply or install or the services they provide. And fitness for purpose is a higher, more onerous obligation. It's an objective standard of achievement. Is it fit for its purpose or not? So contractors should, if they're sensible, seek to exclude or limit their fitness for purpose obligation as far as possible. And in most of the contracts that we're dealing with, they will only be able to do so far as it is reasonable, and there are statutory standards of reasonableness, which I won't go into. But I'm just tantalising you with this, there are exceptions to the fitness for purpose obligation. So there are circumstances in which contractors will not have to meet a fitness for purpose obligation, and I'll bring that in later in the talk. For professionals and for design builders, can there be a higher obligation beyond reasonable skill and care? Yes, there can be, and sometimes there is. And there are a number of cases that look at this, but one case is Greaves Contractors against Bain and Michael. Now, I'm based in the Midlands, and Bain and Michael are still a highly regarded firm of structural engineers based in Birmingham. But the court in that particular case said, where the intention is clear as to what the structure is required for, a term can be implied in law that the design must be fit for purpose. And this was about a warehouse, and it suffered cracking. And the reason it suffered cracking was that forklift trucks were rumbling up and down with barrels of oil. And everybody knew from the beginning that this warehouse was going to be full barrels of oil. And so the court said it was always clear what the purpose of the building was. The forklift trucks set up this vibration which damaged the building. But there was an implied term in that case that the designers would design a warehouse fit for forklift trucks to rumble around with barrels of oil. And another famous case is the television mast in Elmley Moor, where the wind blows across Emily Moor in one direction a lot of the time, and it's very cold and it carries particles of ice built up on the side of the mast. You get what's called vortex shedding, which caused it to oscillate, and it fell down, and the same principle was applied in that case. that they knew what it was for, so there was a reasonable skill and care obligation. But these are the exceptions to the reasonable skill and care obligation, where occasionally, sometimes there will be a fitness for purpose obligation. If you look at the JCT design and build contracts, really through all its editions, there is a limitation on the contractor's design responsibility. The contractor has, in respect of any inadequacy in his design, the same liability as would an architect or professional designer holding himself out as competent. So it's narrowing the design builder's responsibility for design to reasonable skill and care as with a professional. So his design obligation under those design build contracts is reasonable skill and care, but he retains the fitness for purpose obligation for the goods that he installs. And then I just want to mention the state-of-the-art defence. And this is a common defence that designers will use, that they designs to the current state of the art, and if the state of the art becomes more sophisticated later, that's not their problem. They design to the current state of the art. Generally, it is a good defence to say that you designed to the current state of the art, but what we must bear in mind is that there is a continuing design responsibility to correct or alter your design if you later learn, if the state of the art moves on and you later learn that your original design was inadequate. And in the case of Brickfield Properties in Newton, the court said the designer is under a continuing duty to check his design will work in practice and to correct any errors that may emerge. And the continuing duty extends, well, in the case of equitable debenture assets and William Moss, the court decided that the architect had a duty to check the initial design as works proceeded and to correct it if necessary, and the duty only ended on practical completion. But in the case of London Borough of Merton and Low and Pickford, the Court of Appeal decided that this continuing duty to investigate and to amend his design carried on until the final certificate. So by way of a short example, back in, let's say, the 30s, in relation to flat roofs, people had forgotten the problems that there could be with flat roofs in relation to condensation, interstitial condensation, coal roofs, warm roofs, that sort of thing. When a first article emerges in some obscure journal, look, there are problems with condensation, that may not alert the state of the art, that might not comprise the state of the art, that the state of the art is so far changed by that simple obscure article. Once it appears in Architects Journal, one of the leading journals, then it's pretty much out in the open, and then the state of the art would be that people do know about these problems. So it is a matter of fact and degree as to whether the state of the art has changed. Design is choice. Now, this is something that lawyers will come up with all the time. Design is choice as a saying. So just because the contract is a traditional with architect or contract administrator form of contract, that doesn't necessarily mean that the contractor has no design responsibility. I mean, contractors will routinely say, this is a traditional contract, I haven't got design responsibility. But you will always have responsibility for the temporary works and the how of the building process, strutting, propping, scaffolding, those things. You will always have responsibility for the how of the build process. But also, if the specification is silent on matters, and most specifications are silent on issues of detail, certain issues of detail, and then there's more than one choice available, and the contractor simply makes that choice, then he has taken on a design responsibility, and he'll be liable if he chooses wrongly. So Hudson's Building and Engineering Contracts, the sort of Bible on construction contracts, states as a broad generalization, if the contractor himself designs or selects materials for work, either because he provides the whole design himself or because a part of the design is left to his judgment or choice, there will be an implied term that the works or materials will be suitable for their purpose. So examples of that could be the mix of concrete in reinforced concrete design, choosing the right mix of mortar, where it's a bricks and mortar situation, and choosing the right lengths of nails and screws. So increasingly we have single ply membranes on roofs. If you choose a nail that's too wrong and it punctures that membrane, then you've got all kinds of problems. So those simple choices. But to give you an example, I was involved many years ago in the Sun Valley poultry case, which was a huge case. And in Sun Valley poultry, they have chickens which go along conveyor belts through ovens and come out cooked at the other end. So huge potential for fire through the heat and the fat. And that's exactly what happened. In that particular sad scenario, firemen went in to put the blaze out. 2 firemen were incinerated because the suspended ceilings collapsed. The court looked at why had the suspended ceilings collapsed, because in the end it proved that a gang of subcontractors just handed out bags of nylon screws and used them. And that was inappropriate for a fire risk location. So, and then that risk would pass all the way up to the main contractor who would have undertaken design liability. So you can see how desperately serious sometimes these simple choices can be. So the solution for the contractor is not to say, I'm a specialist, I know what to do here, I'll sort this out, but to request an instruction not unreasonably late and get that instruction confirmed in writing where there are a number of options and where he is otherwise making that choice. And then contractor's duty to warn. A contractor may have a duty to warn of various things. He can't just sit back and mindlessly comply with what he's being told to do. He would have a duty to warn that a practice is dangerous or impracticable or unsafe, and a duty to warn of economic consequences. This is going to be phenomenally expensive, which you quite often get in relation to electrics, where you add another component and that will overload the circuit, which will require a new network and so on and so forth. You've got to say you're adding a £50 component here, but it's going to cost £250,000 for those reasons to add it. And inequitable debentures and MOS, which I've mentioned, again, there was a duty on the contractor to warn the employer and the contractor of design faults. And this included where they were working in a windy environment on scaffold, carrying sort of huge glazing components around. There was a duty to warn. In Lindenberg and Canning, it was a classic situation where an experienced builder was given a set of drawings which showed too many non-load bearing walls. The architect had marked with a tick and a cross and marked too many as non-load bearing, and there was a loud creaking sound and everybody stood back after they got their lump hammers and knocked out too many walls. And the judge was fairly robust in saying any competent contractor should have known he was knocking out too many walls. There was a duty to warn. So the primary liability would be on the employer or the employer's team, but there would be some significant liability on the contractor, possibly, say, for example, 30% liability. So going back to my, are there exceptions to the fitness for purpose obligation? Workmanship and materials are generally required to be fit for purpose under the Supply of Goods and Services Act. There's a statutory implied obligation of fitness for purpose for goods and services unless the recipient does not rely, 1, or 2, it's unreasonable for him to rely on the skill and judgments of the contractor. So you may be able to show effectively to blame somebody else. So you don't meet the acoustic properties of a block of flats. As a contractor, you say, but actually you did not rely on me. You relied on the acoustic consultants in whom you put great faith. Give you an example. I was dealing with a penstock, which is a dry dock once, and the seals failed, and my client had supplied the seals in this corrosive, aggressive marine environment. So the client was literally, and his insurers were literally about to admit liability. So I said, well, let me have a look at the specification. And there was a 27-page specification with all the different metals, manganese, bronze, titanium, whatever. The stoving requirements were all set out in great detail. So exactly what was required was fully specified. And we were able to argue successfully that there had been no reliance on the contractor, although he installed it. That was a good many years ago. And I just want to finish off by referring to a case which I can't pronounce. It's Dutch name. It's MT, I think, Hogarth, but it's HOJGAARD against Eon Climate and Renewables. And this is a Supreme Court case from 2017. And simply, in that case, the contract contained a requirement, a specification that goods comply with a particular design criteria, and B, a performance criteria which had to be met. But at trial, it was common ground that if you met the specification, the design criteria, you wouldn't meet the performance criteria. The court made a point of this, and it said, the courts are generally inclined to give full effect to the requirements that the item as produced complies with the prescribed criteria, on the basis that even if the customer or employer has specified or approved the design, it's the contractor who can be expected to take the risk if he's agreed to work to a design which would render the item incapable of meeting the criteria which he has agreed. So they were saying fairly clearly, in that situation, it's your risk, Mr. Contractor, if the specification doesn't meet the performance criteria. And in fact, the court made a point of doing this, even though in that particular case, the contract had said that the relevant design criteria were the minimum requirements, and it was the responsibility of the contractor to identify any areas where works needed to be designed to an additional or more rigorous set of requirements. So they made this point of principle in that case, even though they didn't need to, because the contract actually already imposed the obligation on the contractor to meet a higher set of standards if need be. So it seems likely that this principle in the Hogarth case will continue to apply. The risk is on the contractor if the specification can't meet the design, can't meet the performance criteria. So there we are, a quick gambit through, a quick canter through some of the points on design law in construction contracts as our fourth Law Bites takeaways, and I hope you find that some use. Thank you very much.